Okay, imagine this. You've poured years of your life, maybe sleepless nights, probably a significant chunk of funding, into creating something genuinely new and useful. You secure a patent, this powerful legal document that essentially gives you a temporary exclusive right to your invention. It feels solid, like your innovative ground is protected.
Mm,
But then someone else starts doing exactly what your patent says only you can do. They're making it, using it, selling it without your permission. That feeling,
yeah,
that's the real-world impact of patent infringement.
it really is. It's the moment the abstract legal right granted by the patent collides with actual commercial activity. So
Mm.
where the rubber meets the road for the patentee, forcing them to defend the boundaries of their invention in the marketplace.
And that's precisely the landscape we're diving into today. Our mission in this deep dive is to explore the fascinating, sometimes challenging world of patent infringement under UK law. We'll be looking at what specific actions constitute infringement, what rights the patent owner has, and crucially, the range of arguments and defenses available to someone accused of stepping onto that patented territory, including, challenging the very existence of the patent itself.
Yeah, that's a big one.
And we're drawing our insights for this exploration directly from detailed academic materials that really lay out the statutory provisions and the landmark court cases that define this area.
And it's worth saying, these materials have been made available by the University of London for educational purposes, and we gratefully acknowledge their contribution to making this knowledge accessible.
Absolutely. And we also want to let you know that this deep dive is proudly brought to you by Sinorbit Academy, Sri Lanka.
And importantly, to all of you using this deep dive as part of your studies, maybe gearing up for exams, we want to wish you the very best of luck.
Yes, massive good luck. Our goal here is to help make these key concepts, statutory sections, those important case names, and facts really stick. Think of this as us walking through the material with you, helping you consolidate your understanding and maybe flag up what's most critical.
Exactly. So our roadmap for this deep dive will take us through the fundamental definition of patent infringement, then a detailed look at the specific prohibited acts listed in the law, the various defenses a defendant can raise, the powerful option of challenging a patent's validity through revocation.
Which we just mentioned.
Right. And finally, we'll tackle the often complex but absolutely central issue of how courts interpret patent claims, especially, in light of recent Supreme Court decisions that have really, well, changed the game.
It's an area of law that is constantly being tested and refined by the courts. It's where technical detail meets legal principle, and getting your head around it is key to navigating the innovation landscape. Let's jump in.
Okay, let's unpack this complex area.
So let's lay the foundation. At its heart, what does the law say patent infringement is?
Okay, at its most basic level, patent infringement in the UK is defined as a statutory tort. Now, a tort is a civil wrong defined by law, distinct from a criminal wrong or, say, a breach of contract. So the Patents Act, 1977, specifically creates this legal wrong,
Right.
giving the patent holder, the patentee, the right to take legal action to stop others from exploiting their patented invention without their explicit consent.
Okay, so the law creates this specific defined wrong, and if someone commits it, the patent owner has a right to sue them. Pretty straightforward so far.
Pretty much. And just like with other registered intellectual property rights, such as, registered designs or trademarks, the types of conduct that can constitute infringement are broadly categorized into direct infringement and indirect or contributory infringement.
Okay, direct and indirect. We'll definitely dig into those details soon. But the source material flags something really crucial right at the start about the defendant's perspective. What's the sort of best line of defense when you're accused of infringing a registered right like a patent?
Yeah, this is a critical strategic point you see play out in almost every patent case. When facing a claim based on a registered right, often the most powerful defense available to the defendant is to challenge the validity of the right itself.
So they're not just saying, I didn't do it or I had a good reason. They're actually saying you didn't have a valid right to begin with. Is that it?
Exactly that. The argument is, essentially, even if I did what you say I did, I cannot have infringed your patent because your patent should never have been granted in the first place.
Okay.
If the defendant can prove that the patent is invalid on one of the grounds set out in the statute,
Which we'll get to.
which we will, yes,
It-
they can seek its revocation.
Revocation. That sounds pretty final.
It is, yeah, absolutely. If the court agrees that the patent is invalid and revokes it, it's treated as if the patent never existed. So it's a complete answer to the infringement claim. It's like trying to sue someone for trespassing on your land, only for them to prove that the land you claimed was yours actually belongs to someone else or, never properly belonged to you.
Right, that makes the link between infringement and validity incredibly tight then. So for the patent owner bringing the lawsuit, what are the essential elements they must prove to establish that infringement has actually occurred?
The source outlines two primary things a patentee claimant needs to demonstrate, and these are rooted in Section 60 of the Patents Act 1977. First, they must prove infringement in law. This basically means showing that the defendant has performed one or more of the specific acts that Section 60 prohibits concerning a patented invention.
Okay, so first hurdle. Prove they did one of the bad things listed in the act. What's the second element?
The second element is infringement in fact. This is about proving that the defendant's specific conduct, whatever that prohibited act was, falls within the actual scope of protection afforded by the patent.
And how is that scope determined? It can't just be whatever the patentee thinks their invention covers, surely.
Oh, absolutely not. This is where the patent's written specification, and particularly the claims, are absolutely paramount. The scope of protection of a patent is defined by its claims. That's their job. So the court's task is to interpret, or the legal term is construe, those claims, often looking at the rest of the specification and any drawings to understand what the inventor intended.
Okay.
Then the court compares the alleged infringing product or process to the construed claims to determine if it falls inside that protected territory. The source mentions cases like Dyson Appliances Ltd v. Hoover Ltd. as a classic examples of this comparison process playing out in court.
So the claims are like the boundary markers on a property deed, and the court interprets where exactly those markers are placed based on the language used, and then sees if the defendant's activity crossed that line. Is that a fair analogy?
That's a very good analogy, yes. The precise wording of the claims and how a court understands that wording through the eyes of a hypothetical skilled person in that field is absolutely fundamental.
Given all that, let's quickly summarize the defendant's main strategies for fighting back against an infringement claim. What are their options?
Okay, based on the source material, a defendant essentially has three main lines of attack. One, they can simply deny the claimant's case, arguing that the patentee failed to prove either infringement in law, that they actually did a prohibited act, or infringement in fact, that their act falls within the claim scope.
Just say you haven't proven it.
Right. Two, they can argue that even if they committed an otherwise infringing act within the scope, a specific statutory defense applies to their situation, which legally excuses their conduct. We'll look at those later.
Okay.
And three, perhaps the most devastating for the patentee, they can seek revocation of the patent itself, arguing it was invalidly granted from the outset.
So deny the facts, claim a legal exemption, or blow up the patent itself.
That's a pretty good way to simplify it, yes. A successful revocation is a complete knockout blow to the infringement claim.
Okay, good. So to recap this foundational section, patent infringement is a statutory tort under the Patents Act 1977. It means committing specific prohibited acts defined by law that fall within the scope of the patent claims as interpreted by the court. When accused, a defendant's most powerful defense is often challenging the patent's validity through revocation, but they can also deny the facts or rely on specific statutory defenses.
That sets the stage perfectly for looking at the specifics.
Great. Let's move into Section 2 then and really unpack those prohibited acts under Section 60 of the Patents Act 1977. What exactly does the law forbid you from doing with someone else's patented invention without their permission?
Well, historically, before the 1977 Act came along, infringement wasn't actually defined in the statute itself. It was left for the courts to interpret the scope of the patent grant wording. The 1977 Act changed that by providing a statutory definition. Now, a key principle underpinning these prohibited acts is that they almost always involve some form of, commercial activity. Cases like British United Shoe Machinery Co. v. Simon Collier and SKF v. Douglas sort of reinforced this idea early on.
So, generally speaking, someone just tinkering with a patented widget in their shed purely for fun isn't typically going to get sued for infringement.
Generally, no. While we'll touch on defenses like private use later, the main focus of Section 60 is definitely on commercial exploitation. Another critical point the source highlights, and this often surprises people, is that for the most part, intention is irrelevant to liability for infringement.
Really?
Yes. As established in the much older case, Proctor v. Bennis, you don't need to intend to infringe or even know about the patent's existence to be found liable for committing an infringing act.
Whoa, hang on a minute. So if I innocently develop a product or maybe use a process that just happens to be patented without ever knowing about the patent, I can still be found liable.
For the act itself constituting infringement, yes, you can. However, your state of mind isn't entirely irrelevant. While it doesn't prevent liability, innocence, if the defendant can objectively prove it, can significantly affect the remedies the court awards. Specifically, it can limit or even prevent the award of damages, as noted in Section 62. But the core finding of infringement itself can stand regardless of your intent or knowledge.
Okay, that's a really crucial distinction. Liability versus the like damages. Got it. So tell us about the specific acts listed in Section 60.
Okay, Section 60 is divided up. Section 61 deals with what we call direct infringement. This covers the primary acts relating directly to the patented product or process. Then Section 62 covers indirect or contributory infringement, which deals with supplying the means to infringe. The source also mentions a helpful reclassification by Professor Cornish, thinking about these acts chronologically in relation to a product. Acts before manufacture, acts during manufacture, and acts after manufacture.
Let's focus on direct infringement under Section 61 first. What are the fundamental conditions for an act to be directly infringing? What has to be true?
Okay, two key conditions run through Section 61. The act must be done without the consent of the patentee, obviously, and, very importantly, it must be done within the United Kingdom. The geographical limit to the UK is firm. That's underscored by cases like Menasha Business Mercantile Ltd v. William Hill Organization Ltd. Also, and this is sometimes overlooked, the patent must actually be in force at the time of the act, meaning the annual renewal fees have been paid up to date.
Right, can't infringe an expired patent. And Section 61 covers different acts depending on whether it's a product patent or a process patent.
Yes, absolutely. The claims of the patent will define whether it's primarily a product patent, protecting a physical device or substance, or a process patent, protecting a method or way of doing something. Of course, a single patent can have claims of both types. Section 61A lists the prohibited acts for product patents, and Section 61B and C list them for process patents.
Let's break down the specific acts for product patents under Section 61. The source highlights several key terms: making, importing, disposes of, offering to dispose of, using, and keeping. Now, making seems straightforward enough, but there's a famous legal tightrope walk here, isn't there, between making and...
Ah, yes, the critical distinction between making and repair. This is a very frequently litigated issue. While a patent grants the exclusive right to make a product, it's generally accepted that someone who has legitimately acquired a patented product has an implied right to repair it to keep it functional. The big question is, at what point does a repair become so extensive that it crosses the line and actually constitutes the making of a new product? Because that would be infringement.
So replacing a worn-out screw is okay, probably, but replacing, say, most of the components or maybe the key inventive parts might actually be classed as making.
Precisely. And there's a very important Supreme Court case that tackled this issue head-on. Schutz v. Werit. It was decided in 2013 under UKSC 16. This case involved those large reusable bulk waste containers, the ones with a metal frame cage and a large inner plastic bottle-like container.
Right, I think I know the ones.
While the defendant, Werit, was replacing the inner plastic container after it got damaged or worn out, Schutz, the patent owner, sued them for making the patented container. Lord Neuberger, giving the judgment for the Supreme Court, held that deciding whether an activity is a repair or a making is really a matter of context. You have to look at all the relevant factors in the specific situation.
What were those factors in the Schutz case? What made it a repair?
In Schutz, replacing the inner container was ultimately deemed a repair, not a making. The key reasons were that the inner container was a separate, self-contained component. It was freestanding. And, importantly, replacing it didn't involve recreating the core inventive concept of the overall container design, which was more about the combination of the cage and the inner bottle and how they fit and work together. The inner part was essentially seen as a consumable or replaceable element. So the Supreme Court concluded that replacing a freestanding, essentially non-inventive component was a repair in this context, not the making of a new container. This case, Schutz v. Werit, is absolutely fundamental to understanding the making versus repair distinction in UK patent law. If you're studying this, you really need to know Schutz v. Werit cold.
So the nature of the part being replaced, whether it's kind of integral to the inventive concept, its standalone nature, those are key factors in distinguishing repair from making.
Exactly. It's not a simple bright line rule, it's fact-dependent, but Schutz provides the essential framework for that analysis.
Okay, good to know. What about the other acts for product patents? Importing seems pretty self-explanatory, just bringing the patented product into the UK from elsewhere.
Yes, that one's relatively straightforward. Then you have disposes of and offering to dispose of. These generally cover selling or offering to sell the infringing product. Disposes of is interpreted quite broadly. It can include things like purchasing with the intention to immediately export it, as was shown in the old case United Telephone Co. v. Sharples.
Right.
And offering to dispose of is also interpreted broadly, going beyond just a formal contractual offer. Displaying the product at an exhibition, for instance, has been held to count as an offer to dispose, Dunlop Tire Co. v. British and Colonial Motor Co. And simply advertising it for sale would also fall within this category.
So even just marketing or showing the product publicly can be an infringing act, not just the final sale itself. Interesting. What about using and keeping?
Using implies some sort of active engagement with the product for its intended purpose. Merely possessing a collection of unassembled parts wouldn't typically be considered using them. That came up in British United Shoe Machinery Co. v. Simon Collier. Keeping, which was a term introduced specifically in the 1977 Act, means possessing the product for the purpose of sale or trade, essentially, stocking it. It doesn't usually cover someone who is merely storing it as, say, a warehouse keeper or a carrier who isn't involved in the actual trade. SKF v. Harbottle. It implies possession with the intention to trade for profit, as suggested in Hoffman-LaRoche v. Harris.
Okay, that clarifies those acts for product patents. Now, what about process patents under sections 6D, B, and C? What acts are prohibited there?
For processes, the main prohibited acts are actually using the patented process within the UK, offering the patented process for use in the UK, and then under C, dealing with a product obtained directly by means of that process.
So the product itself becomes tainted if it's made using an infringing process.
Exactly. If you use an infringing process, any product that comes directly out of that specific process is considered an infringing product. And consequently, you cannot then dispose of, offer to dispose of, use, keep, or import that resulting product within the UK without infringing the process patent. That's section 61C.
Okay, so if I use your patented method for making a certain chemical, the chemical I produce is effectively off limits for me to deal with in the UK.
That's the effect of 61C, yes.
You mentioned earlier that knowledge can sometimes be relevant, particularly for process patents. Where does that come in?
Yes, but it's quite specific. Knowledge is required only for the act of offering the process for use under section 61B. To infringe by offering a process for use, you must have knowledge, or it must be obvious that using that process would constitute an infringement of the patent.
And how does a court assess that knowledge? Is it subjective, what the person actually knew?
No, the test for this knowledge is objective.
Yeah.
Would it be obvious to a reasonable person in the circumstances that using the process would infringe?
How does that obvious to a reasonable person standard work in practice? How would a court figure that out?
Well, the analogy often used is similar to assessing knowledge requirements in copyright law. For instance, under Section 22 of the Copyright Designs and Patents Act, L.A. Gear v. High-Tech Sports was mentioned. A reasonable person in the defendant's position would be expected to act diligently. And there's a key case here which is particularly important for commercial actors operating in a specific field. Tamglass Ltd. Oy v. Loyang North Glass Technology Co. Ltd. It's a 2006 case, FSR 608.
Tamglass, okay, what did that establish?
The court in Tamglass basically inferred knowledge on the part of the defendant. The reasoning was that companies operating in industries where patenting is common, especially those who themselves seek patents or actively exploit technology, are expected to be aware of the patent landscape in their area. They should be conducting regular searches of patent databases.
So if you're a sophisticated player in a relevant industry, you can't credibly just shrug and claim ignorance of a relevant patent when you're offering a process that turns out to infringe. That's a really significant takeaway for anyone doing business in patented fields.
It certainly places a considerable burden of due diligence on commercial entities. Willful blindness won't cut it.
We also briefly mentioned earlier that amendments made to a patent after it's granted can sometimes play into infringement findings. How does that work?
Yes, the case of Insignia v. Shell from 2023 is a recent illustration of this point. It highlights how if a patent is amended after it's granted, maybe during litigation or in separate proceedings, and that amendment impermissibly adds matter, which, by the way, is also a ground for invalidity under Section 72.
Right, another link to validity.
Exactly. A court might then find that the alleged infringing product doesn't actually fall within the scope of the claims as amended, even if it might have fallen within the scope of the original unamended claims. It just reinforces how the exact wording of the claims at the time of the alleged infringement is what matters, and how validity issues stemming from amendments can directly affect the infringement outcome.
That really underscores how validity and infringement are constantly intertwined, doesn't it? Let's try to use the cuprocillin example from the source's activity to maybe solidify the application of these S.601 concepts. So, Supermed has a UK patent for the drug cuprocillin. Molds Ltd makes and supplies it in the UK. Pharmagen imports and supplies it, and Black's Chemists and Barsetshire Hospital use and keep it. Assuming product claims, who is potentially committing direct infringing acts in the UK?
Okay, let's break that down. Assuming none of these parties have a license from Supermed, of course. Molds Ltd. Is making the drug in the UK, so they are committing the act of making under 601A. When they supply it to Pharmagen, they are disposing of it and likely offering to dispose of it as well.
Right, and Pharmagen, the wholesaler in the UK.
Well, Pharmagen receives the infringing product. If they bring it in from outside the UK, as a variation in the example suggests, they are importing it. When they supply it onwards to the chemists and hospital, they are disposing of and offering to dispose of it, and by holding stock in their warehouse, they are also keeping the infringing product.
Okay, makes sense. And the end users, Black's the Chemists and Barsetshire Hospital.
When Black's sells the drug over the counter to a patient, or when the hospital dispenses it to a patient, they are disposing of it. The hospital's actual administration of the drug to a patient, or indeed the patient's own use of the drug, would constitute using the product. And both Black's and the hospital, by holding stock on their shelves or in their dispensaries, are keeping the product. So potentially Molds, Pharmagen, Black's, and the hospital are all directly infringing parties under UK law, each committing different prohibited acts listed in SP 21A.
Okay. What about the variation where Molds arranges for the actual manufacture to be done by Pasteur SA over in France, and then the finished drug is imported into the UK? Does Molds avoid infringement then?
That's a good question. Molds arranging for the manufacture in France and Pasteur's manufacturing itself in France are acts occurring outside the UK. So those specific acts are not infringing acts under the UK patent because of that strict geographical limitation. Mold wouldn't be liable for the act of making under the UK patent in that scenario.
Okay, so the UK territory is absolutely key for the act itself to be infringing here.
Exactly. However, that doesn't mean Molds is necessarily off the hook entirely. Molds could potentially still be liable as a joint tortfeasor if they are a UK company substantially involved in orchestrating the downstream UK infringement by others. And crucially, Pharmagen, by importing the drug from France into the UK, is definitely committing an infringing act, importing under S60. And then all the subsequent acts by Pharmagen, Black's, and the hospital within the UK, offering, disposing, keeping, using, are still infringing acts committed by those UK parties. So the foreign manufacture itself isn't actionable under the UK patent, but the UK activities with the resulting product absolutely are.
That makes the different categories of acts and the territorial limit very clear. So direct infringement covers specific acts like making, using, selling, etc. within the UK, and we noted knowledge is needed for offering a process with a pretty strong expectation for commercial actors to search patents, TAMGlass. Now, let's look at indirect infringement under Section 62. Who does that catch?
Okay, indirect infringement, sometimes called contributory infringement, is covered by Section 62, and it's subject to a specific defense in Section 63. It's designed to catch parties who supply something essential that enables someone else, the primary infringer, to perform a direct infringing act.
So I'm not doing the main patented thing myself, but I'm supplying, say, the crucial ingredient or maybe a unique component to someone else who is doing the patented thing.
That's the core idea, yes. The conditions under Section 62 are quite specific. You have to supply or offer to supply a tangible means, so a physical thing in the UK. That tangible thing must relate to an essential element of the invention. The supply must be for the purpose of putting the invention into effect. And importantly, the supplier must know, or it must be obvious to a reasonable person, in the circumstances that the means supplied are suitable for putting the invention into effect and are intended to put it into effect in the UK.
The knowledge requirement there sounds a bit different again from the one for offering a process, is it?
It is subtly different, yes, and this distinction is important. For offering a process under S60B, the knowledge required is that using the process would infringe the patent. For indirect infringement under S602, the knowledge required is that the means supplied are suitable for putting the invention into effect, and that effect would be an infringement. It's focused more on the functionality of the supplied item and its direct link to the infringing outcome, not necessarily direct knowledge of the patent number itself, although, again, an objective standard applies, would a reasonable person know.
Okay, so supply a physical essential part in the UK for the purpose of putting the invention into effect, knowing, or it being obvious, it will make the invention work and infringe. Is there any way for a supplier of such a part to avoid liability? A defense.
Yes, that's the crucial defense built into Section 63, the staple commercial product defense. There is no liability for indirect infringement if the tangible means supplied is considered a staple commercial product.
And what does staple commercial product mean in this context, like nuts and bolts?
Pretty much yes. It means something that is widely and readily available from multiple sources and is suitable for a variety of different uses, not just for the specific infringing purpose. It's contrasted with, say, a component that has no practical use other than in the patented invention, or perhaps is custom-made specifically for that infringing use. The case of Nestec SAV Duet Ltd. from 2013 provides helpful guidance on the meaning of staple commercial product under SPFO 63, and is actually a good example of indirect infringement principles in action. Also worth remembering Grimm Machine and Fabric GmbH v. Scott from 2010. That's an important Court of Appeal case providing significant guidance on Section 62 generally.
Okay, so supplying a standard nut or bolt, or maybe a common chemical, wouldn't usually trigger indirect infringement, even if it happens to be used later in an infringing product, because they are staple products with many uses. But supplying, say, a uniquely shaped connector piece that only fits into the patented machine would likely be indirect infringement if done with the necessary knowledge.
Exactly. The defense is there to avoid holding suppliers of general-purpose items liable just because those items happen to be used downstream by someone else in an infringing manner. It keeps the focus on things supplied specifically for the infringing purpose.
Right. Are there any other ways a party can be held liable for infringement beyond direct infringement under S.601 and indirect under S.302?
Yes, the source material mentions that a patentee can also sometimes pursue parties as joint tortfeasors. This isn't strictly covered by Section 60 itself, but is based on general principles of tort law, the law of civil wrongs.
How does that work in the patent context? Joint tortfeasors.
It typically applies in situations where parties are involved in a common design to infringe the patent, or where one party actively induces another party to commit the infringing act. This can be particularly useful for a patentee if the primary direct infringer, the one actually making or using, is located outside the UK jurisdiction, but maybe a UK-based entity is substantially involved in facilitating or orchestrating the infringement happening elsewhere or the import into the UK.
So maybe a UK company directs an overseas manufacturer to make infringing goods and then arranges for their sale by others in the UK. Could that make the UK company a joint tortfeasor?
Potentially, yes. However, the threshold for establishing joint tortfeasorship is quite high. Simply supplying infringing goods to a UK purchaser isn't usually enough to make the supplier a joint tortfeasor. The UK party must somehow make the infringing acts their own through their level of involvement and common purpose. That was highlighted in the Sibof's BAV Meneghetti case back in 2003.
Okay, so Section 60 defines the main acts, direct and indirect, but other related tortious conduct linked to the infringement can also be actionable under general law. A final point on timing. When can a patentee actually start legal proceedings for infringement? Can they sue as soon as they file the application?
No, you can only formally sue for infringement after the patent has actually been granted by the Patent Office. However, the law recognizes that infringement might occur during that sometimes lengthy period between when the patent application is published, making it public knowledge, and when it's actually granted. Section 69 of the Patents Act provides a mechanism for this. It allows the patentee, once the patent is granted, to claim damages for infringing acts that took place during this pre-grant, post-publication period, provided certain conditions are met.
So the clock for claiming damages can actually start ticking before the patent is even officially granted, from publication onwards.
Yes, exactly. From the date the application is published in the official patents journal. This offers important protection to the inventor during that potentially vulnerable examination phase. It's also a good reminder, as the source notes, of the steps in the patent prosecution process you might have covered back in Chapter 15.
Okay, great. To quickly summarize Section 2 then. Infringement means committing specific, primarily commercial acts relating to the patented invention within the UK. These are defined in Section 60 as direct infringement, making, using, selling, etc., and indirect infringement, supplying essential components with knowledge unless they are staple commercial products. Intention generally isn't required for liability, but innocence can limit damages later. S.62. We flagged the crucial Schutz v. Weirett case on making versus repair and Tamglass on the objective knowledge test for offering processes. Liability can also arise through joint tortfeasorship. And while you can only sue after grant, damages can potentially be backdated to the application publication date under S.69.
That covers the various ways infringement can actually occur under the Act.
Excellent. Now let's turn to Section 3, defenses. If a patentee manages to prove infringement, they show an act under S.60 happened within the scope of the claims. What legal arguments can the defendant then use to try and avoid liability?
Okay, so these are specific statutory exceptions or case law doctrines that, even if an otherwise infringing act occurred within the scope of the claims, mean the defendant is ultimately not liable for infringement.
Where are these defenses primarily found? In the act itself.
Many of them are found in the Patents Act itself, yes, notably in Section 65 and Section 64. Others have developed through court decisions over time, common law defenses, if you like.
Let's start with the statutory defenses listed in Section 65. What's the general thinking behind these exceptions? Why do they exist?
The underlying principle here, as the source notes, is really one of balance. The law acknowledges that certain activities shouldn't be caught by the patentee's monopoly because they serve other important public interests or are generally considered legitimate activities by third parties that shouldn't be restricted. Most of these defenses, though, are quite specific and apply only in particular factual situations.
Can you give us a few examples from the statute?
Sure. The source mentions, for instance, acts done privately and for non-commercial purposes, or acts done for experimental purposes relating to the invention. We'll come back to those. But there are also very specific ones, like certain activities carried out by a pharmacist when dispensing a prescription, that's S.605C, or specific defenses for farmers concerning the use of patented biological material for reproduction on their own farm, often called farmer's privilege, that's S.605G, which stem from requirements under the EU Biotech Directive.
Oh.
And there are also defenses for activities involving vehicles, ships, or aircraft that are only temporarily within UK territory. That's LS.605.
Temporarily present, like a foreign ship just passing through UK waters or docking briefly for supplies.
Exactly. And the case of Stenarederi Aktiebolag v. Irish Ferries Ltd. from 2003 clarified the meaning of temporarily in this context. The Court of Appeal held that temporarily simply means for a limited period. Importantly, the fact that a ferry might call regularly at UK ports didn't prevent its presence on each occasion from being considered temporary for the purpose of this defense. So regularity doesn't automatically negate the temporary nature of each individual visit.
That's a useful clarification, especially for transport industries. What are the more broadly applicable defenses within Section 65 that might come up more often in general disputes?
The two most significant ones, as I mentioned, are probably private and domestic use and experimental purposes. For private and domestic use, the activity must be genuinely for personal, private purposes. It must not be kept secret, interestingly, but crucially, it must not be for commercial purposes. The SKF v. Evans case from 1989 confirmed that private here simply means personal, not necessarily secret.
Okay, non-commercial personal use. What about the experimental use defense? This sounds really important for research and development.
It is, potentially. This defense permits activities carried out for purposes relating to the subject matter of the invention. The policy behind it goes back to older cases like Frierson v. Lowe from way back in 1878, which stated the defense exists to allow individuals to exercise their ingenuity and understand patented technology without fear of being sued. However, just like the private use defense, this one is strictly limited. The conduct must not have an overriding commercial purpose.
How do courts figure out if there's an overriding commercial purpose? That sounds like it could be tricky.
It can be. This is a key point of contention in many cases involving this defense. For example, if the experiments are essentially trials primarily aimed at gathering data required to get regulatory approval, like from a medicines agency, before selling the product, that's generally considered a commercial purpose, and the defense won't apply. The Monsanto v. Stauffer chemical case from 1985 established this principle quite clearly. The SKF v. Evans case also showed a limitation. Experiments carried out on the subject matter of one patent weren't protected by this defense if the primary goal was actually to generate evidence to challenge the validity of a separate but related patent. The experiments must genuinely relate to the subject matter of the invention itself.
And what if the activity has multiple purposes, maybe some genuine experimentation, but also some commercial aims mixed in?
That exact scenario arose in a very important case, Corvalvenk v. Edwards Life Sciences AG from 2009. This involved clinical trials of a patented artificial heart valve device being carried out in hospitals. Now, these trials had potentially mixed aims, developing surgeon confidence in using the device, gathering technical data on its performance, maybe improving it, but also potentially generating revenue for the hospitals and perhaps indirectly for the company promoting the device.
So a mix of science and commerce.
Exactly. The court had to decide what the main purpose of the activity was. If the data gathering for scientific understanding wasn't the predominant purpose, then the experimental use defense might not be available. This case, core valve, is absolutely essential for understanding how courts approach activities with these mixed experimental and commercial goals. They look for the predominant purpose. You really need to remember core valve for that point.
Okay, so the S.605 defenses are quite narrow, generally fact-specific exceptions, primarily aimed at non-commercial, personal, or specific transit-related activities. They're not broad get-out clauses.
That's a very good summary. They provide a necessary safety valve in certain situations, but are not wide-ranging exemptions from infringement.
What about the prior use defense? That's in Section 64, right?
Yes. Another statutory defense, sometimes called the prior user right, it's based on the fairly intuitive principle that if you were already doing the relevant act, maybe using the patented process, or making or stocking the patented product before the patentee's priority date, you should generally be allowed to continue doing so, even after the patent is granted.
So it's like an I was here first argument. If I can prove I was making this specific product before the patentee even filed their application, I might have a defense.
Yes, that's the core idea. The crucial date is the patent's priority date, which is usually the date the first patent application for that specific invention was filed anywhere in the world. The source does note, however, that courts have tended to interpret this section quite narrowly, meaning the requirements for successfully claiming the defense are pretty strict.
Any examples?
Well, the Luzol v. Esso Petroleum Ltd. Case from 1998 is cited as an example where the defendant was ultimately unable to successfully rely on this defense. It likely means that the nature or scope of their prior activity didn't exactly match the strict criteria set out in Section 64.
So demonstrating you were doing something kind of similar before the priority date might not be enough. It really has to be the specific act covered by the patent, and you have to prove you started it before the crucial date.
That's often the challenge with this defense, proving that your prior activity falls squarely within the precise requirements of the statute. It's not always easy.
Okay, let's move on from the statutory defenses and look at some important defenses that have developed primarily through case law. What are the key ones?
The first major one the source discusses is the exhaustion of rights doctrine. This stems originally from EU law and the jurisprudence of the Court of Justice of the European Union, CJEU. In the patent context, a key early case often cited is Centropharm v. Sterling Drug from 1974.
Exhaustion of rights. This sounds familiar. Doesn't it come up in other IP areas like trademarks as well?
Yes, exactly. The underlying principle is similar across different types of IP rights, particularly within the European Economic Area, EEA. The doctrine basically states that if a patented product is placed on the market anywhere within the EEA, by the patentee themselves, or with their explicit consent.
So the first authorized sale?
Right, the first authorized sale within the EEA. Then the patentee's rights regarding that specific physical product are considered exhausted throughout the rest of the EEA.
What does exhausted actually mean in practice for that product?
It means that that specific product, once it's been legitimately sold in, say, France with the patentee's permission, can then be freely imported into and sold in any other EEA country, like the UK, without infringing the patentee's corresponding patent rights in those other countries. So, if a pharmaceutical company sells its patented drug in Germany, someone can legally buy that specific batch in Germany and then import it for resale in the UK without infringing the UK patent that covers the same drug.
Okay, so the patentee gets their reward from the first sale somewhere in the EEA, and after that, they generally can't use their national patent rights to stop the free movement of that specific batch of goods within the EEA. Makes sense. What's the next case law concept?
The next one is the implied license to repair. This is a common law doctrine developed by judges with roots in much older cases like Sirdar v. Wallington from 1907. It essentially states that when someone buys a patented product legally, there is an implied license, a sort of unspoken permission that they can perform necessary repairs to keep that product in a serviceable condition.
This links back again to that whole making versus repair issue we discussed under Section 60, doesn't it?
Absolutely. There are two sides of the same coin. The implied license grants the right to repair, but, and this is the crucial limitation, it does not extend to manufacturing a total replacement of the product, or rebuilding it to such an extent that it's effectively a new making. This is exactly the difficult distinction that the highest courts have grappled with over the years, including the House of Lords and United Wire LTD Screen Repair Services, Scotland Ltd in 2000, and of course the Supreme Court in that key case we keep mentioning, Schutz v. Werit in 2013.
So Schutz v. Werit is not just important for defining what constitutes making under S60, but also for clarifying the boundaries of this implied right to repair.
Precisely. It reinforces that if the activity falls within the legitimate scope of repair allowed by the implied license, then it is by definition not considered making or any other infringing act under Section 60. That's why it's often described as a so-called defense, because it's really an argument that the act complained of didn't actually constitute an infringement in the first place, rather than being a separate defense that excuses an act that is otherwise infringing.
Got it. So there's an implied right to repair, but definitely not a right to remake the whole thing from scratch. And the third significant case law concept mentioned.
This is the famous Gillette defense, sometimes referred to as the squeeze argument, which originates from the very old but still relevant case of Gillette Safety Razor Co. v. Anglo-American Trading Co. back in 1913.
The Gillette defense, that sounds intriguing. How does that work? What's the squeeze?
It's a clever and very common litigation strategy used by defendants, particularly when they are accused of infringing with a product that is a variant of the patented invention, meaning it's not identical to the claims, but maybe achieves a similar result in a similar way. The defendant essentially argues that their alleged infringing product or process is, in fact, within the prior art.
Prior art meaning stuff that was already known, used, or published before the patent's priority date. Stuff that should prevent the patent being valid.
Exactly. Things like earlier inventions, publications, or common practices that mean the patented invention wasn't actually novel or was perhaps obvious when the patent application was filed. By claiming their own product is effectively anticipated or made obvious by this prior art, the defendant puts the patentee on what Lord Moulton, in the original Gillette case, famously described as the horns of a dilemma.
Okay, what are these horns? What's the dilemma for the patent owner?
Here's the dilemma. If the patentee wants to argue for a broad interpretation of their claims, stretching the meaning of the words to try and encompass the defendant's slightly different product because it's a variant.
To catch them for infringement.
Right. They risk proving that their own patent is actually invalid. This is because that broad interpretation might also inadvertently encompass something that was already known or obvious from the prior art, making the patent invalid for lack of novelty or obviousness.
So, they win the argument that the defendant's product falls within their claim scope, but in doing so, they might lose the patent itself because the claims, interpreted broadly, cover old stuff.
Yes, exactly. That's the first horn. The second horn is this. If instead the patentee argues for a narrow interpretation of their claims, sticking closely to the literal meaning in order to keep the patent valid, by distinguishing it clearly from the prior art,
To save the patent.
then the defendant's variant product will likely fall outside those narrowly interpreted claims, meaning there's no infringement.
So either the patent is invalid if read broadly, or the defendant didn't infringe if it's read narrowly. Either way, the defendant wins. That's quite a squeeze.
It is indeed. As Lord Evershed described it later in the Page v. Brent toy products case in 1950, the Gillette defense isn't really a true defense like a statutory exception. It's more accurately described as a method of pleading that cleverly combines arguments of non-infringement and invalidity together. It's deeply connected to the whole issue of how patent claims are interpreted, which we'll be diving into in the next section.
Got it. The strategic Gillette squeeze defense. Very clever. Finally, on defenses, you mentioned earlier that there can be restrictions on the remedies, particularly damages.
Yes, that's right. Under Section 62 of the Patents Act, even if infringement is proven, the court might limit the remedies available to the patentee, particularly the amount of damages they can claim. The most significant limitation here relates to innocent infringement. If the defendant can successfully prove that, at the date of the infringement they were unaware and had no reasonable grounds for supposing that the patent existed, then damages might be significantly limited or even denied altogether for that period of innocent infringement.
How is that innocence assessed? Is it about what the defendant genuinely thought in their own head?
No, crucially, it's an objective test, not subjective. This was confirmed in the case of Wilbeck v. Dawes back in 1966. The court looks at whether a reasonable person, standing in the defendant's shoes with the information available to them at the time, should have been aware that the patent existed.
And given what you said earlier about TAM glass.
Exactly. For sophisticated commercial entities operating in fields where patenting is widespread, it can be very difficult to establish objective innocence, especially after cases like Tamglass strongly suggest they have a duty to be aware of the patent landscape, for example, by searching relevant databases. Claiming, "I just didn't know," might not be enough if a reasonable competitor should have known.
So while intention isn't relevant for the finding of liability itself, proving objective innocence can save you from paying full damages, or at least limit them.
That's the effect of Section 62, yes.
Okay, let's try to sum up Section 3 on defenses. These allow a defendant to avoid liability even if the patentee proves an infringing act occurred within the patent's scope. They include specific statutory exceptions found in S.60 Alive, like private use, experimental use, remembering the main purpose test from Corvalve, and temporary presence of vehicles, clarified in Sinorbit. There's the prior use defense in S.64 if you were already operating before the patent's priority date, though Lubrizol shows it's interpreted narrowly. Then we have case law doctrines. The exhaustion of rights doctrine, Centrifarm, for products first sold with consent in the EEA, the implied license to repair, Schutz v. Wear It Again, allowing repair but not remaking, and the strategic Gillette defense, Gillette, using prior art to create that dilemma on validity versus infringement, and finally, damages can be limited or denied for periods of objectively innocent infringement under S.62.
That covers the main landscape of how a defendant can fight back, even when infringement seems, at first glance, to be on the table.
Great. Now let's talk about the most direct attack on the patentee's position. Actually challenging the patent's validity through the process of revocation. Section 4 is dedicated to this crucial aspect.
Yes, and as we've emphasized a couple times already, successfully challenging the patent's validity is often the most powerful defense strategy because, quite simply, if the patent shouldn't have been granted in the first place, it cannot legally be infringed. An invalid patent provides no rights.
Where can a patent's validity actually be challenged? Is it only in court during an infringement case?
No, validity can be challenged in several forms, most commonly, perhaps, in the context of an ongoing infringement lawsuit. A defendant will raise invalidity as a counterclaim right there in the infringement proceedings. Section 74 of the Patents Act, 1977, explicitly allows for this. But you can also apply for revocation in separate standalone proceedings, either before the Intellectual Property Office, the IPO, or directly in the High Court, specifically asking for the patent to be revoked.
Does someone need to be actively accused of infringement, or maybe show that they're somehow affected by the patent to be allowed to challenge its validity? Do they need standing, as lawyers call it?
No, and this is quite a notable feature of UK patent law. Section 72 allows any person to apply to the court or the IPO for the revocation of a patent. You don't need to demonstrate any specific standing, like being a competitor or someone threatened with a lawsuit. You don't need to show you've been prejudiced by the patent in any way. This was confirmed in the Kern Stores Ltd v. A.B. Hassel case back in 2002.
Wow, so literally anyone can take a shot at knocking down a patent they believe is invalid, even if they have no direct commercial interest.
That's correct. It means someone who isn't even operating in the field could potentially challenge a patent they believe was wrongly granted, perhaps to clear the path for future innovation or simply on principle. It's quite an open system in that regard.
Okay, so anyone can try. What are the legal grounds for doing so? Is there a fixed list of reasons why a patent can be revoked?
Yes, absolutely. Section 72(1) of the Patents Act provides an exhaustive list of the grounds on which a patent can be revoked. You must fit your challenge into one or more of these specific statutory grounds. You can't just make up a reason.
What are the most common and important grounds that we really need to focus on for understanding revocation?
Well, according to the source material, the most frequent grounds relied upon for revocation are those listed in Section 72(1)A and Section 72(1)C.
Okay, let's start with A. The invention is not a patentable invention. What does that cover?
This is probably the widest and most commonly used ground. It essentially means that the patent fails to meet one or more of the core fundamental requirements for patentability that are laid out right back in Section 1 of the Patents Act 1977.
And those core requirements from Section 1 are, remind us.
They are the fundamental pillars of patentability. The invention must be new. That's novelty. It must involve an inventive step, meaning it wasn't obvious to a skilled person in the field at the time. It must be capable of industrial application, it has to be useful in some practical sense, and it must not fall into one of the specific categories of subject matter that are excluded from patentability. things like scientific discoveries, mathematical
Okay.
methods, methods of doing business, or mental acts as such.
Right.
The source rightly emphasizes that you really cannot understand patent infringement and revocation properly without thoroughly knowing these basic requirements of patentability from Section 1. You likely covered these in detail in Chapter 16, and maybe Activity 18.3 touched on this. Lack of novelty, it was already known, and obviousness, it was an obvious development, are by far the most common attacks made under this ground. Here's point 721.
So arguing the invention was actually old news, or that it would have been obvious for someone skilled in the area to come up with it, are direct challenges to validity under S.721. What about the other major ground, S.721C, which is insufficiency? What does that mean?
Insufficiency means that the patent specification, the written document describing the invention, does not adequately describe the invention in a way that would allow someone else skilled in that technical field to actually perform it or carry it out. The source identifies two main ways a patent can be found insufficient, sometimes referred to as classic insufficiency and biogen insufficiency.
What's the difference between those two types of insufficiency?
Okay, classic insufficiency is probably the easier one to grasp. It means the description provided in the patent is simply not clear enough or complete enough or perhaps accurate enough for a person skilled in the art, the hypothetical skilled addressee reading the patent, to actually perform the invention using the information given in the patent document itself. They read the patent, follow the instructions, and it just doesn't work, or they can't figure out how to make it work.
Right, the instructions are just bad or incomplete. What about biogen insufficiency? That sounds like it comes from a case name.
It does, yes. This type is named after the landmark House of Lords case Biogen v. Medeva from 1997. Biogen insufficiency is slightly different. It means that the claims of the patent are broader than the technical contribution or description provided in the specification actually supports. In essence, the inventor has claimed a monopoly that extends over a wider technical field than they have actually described how to achieve or enabled others to perform based on the information within the patent document itself.
So it's like they've claimed ownership of a whole continent, but only provided a map and instructions for exploring a single small island within it.
That's a really good way to put it, yes. The underlying principle, which was clarified by Lord Justice Aldous in the Kirin Amgen Inc. v. Hochist Marion Russell Ltd. case in 2003, is that the specification must enable the skilled person to perform the invention across the full scope of the monopoly claimed. If a patent claims a general principle, that's fine if the description shows the principle is genuinely applicable across the whole claimed range. But if the claims cover, say, a whole class of distinct chemical compounds or different mechanical methods, the description must provide enough information to enable the skilled person to make or use representatives across that entire claimed class, or at least provide a principle that allows them to do so. You can't just claim everything vaguely related to one specific example.
And the House of Lords revisited biogen later, didn't they? What was the takeaway there?
Yes, they did. In the H. Lundbeck ASV Generics UK Ltd case in 2009, Lord Neuberger, giving the judgment, commented that the original Biogen case itself was perhaps quite an unusual case based on its specific facts. He suggested the core question for sufficiency generally remains whether the claims are properly enabled by, and commensurate with, the description provided in the patent specification. Does the description fairly support the breadth of the claim?
Are there any other grounds for revocation listed in Section 72 that are worth briefly mentioning?
Yes, though they tend to be less commonly relied upon than lack of patentability, A, and insufficiency, C. Section 72(1)B allows revocation if the patent was granted to the wrong person, for example, someone who wasn't the true inventor or their legitimate successor in title. And Section 72(1)D is the ground that the scope of the patent has been extended or new technical matter has been added during the examination process or through amendments made after the patent application was filed. This links back to that Insignia v. Shell case we mentioned earlier, which illustrated how impermissible amendments can create validity problems that, in turn, affect infringement findings.
Okay, that makes sense. So the main ways to challenge a patent's validity and potentially defeat an infringement claim are by arguing it wasn't patentable from the start. That's S22(1)A, which brings in all the Section 1 concepts like novelty and obviousness, or by arguing that the description isn't sufficient to support the breadth of the claims. That's S.721, covering both classic insufficiency and the biogen type. And successfully proving any of these grounds listed in S.721 can lead to the patent being revoked.
That's right. That covers the direct attack on the patent itself, which, as we said, is often the defendant's most powerful weapon.
This brings us neatly to arguably the most complex and often the most heavily litigated area in patent law: the interpretation or construction of the patent claims themselves. Section 5 is dedicated to this critical issue. Why is interpreting the claims so absolutely central to nearly every patent infringement case?
Well, because, as we established right at the start, infringement, in fact, means the defendants conduct their product or process falls within the scope of the protection granted by the patent. And that scope is defined exclusively by the words used in the patent claims. Therefore, determining exactly what those claim words mean and what technical territory they cover is absolutely fundamental to deciding whether infringement has occurred or not. It's also notoriously one of the most subjective areas for courts to deal with, involving balancing the inventor's rights with the public's need for certainty.
So the main battle is often less about what the defendant actually did, because that might be clear, and more about what the patent claims actually mean they cover. Did the defendant's actions step inside the lines drawn by the claims?
Absolutely. Defendants rarely make an exact carbon copy, a purely literal infringement of every single word in a claim. More commonly, they make a product or use a process that is a variant of what's literally described in the claims. Maybe it works in a similar way, but uses slightly different components or steps. The court then has the difficult task of deciding if that variant is close enough, legally speaking, to still fall within the monopoly granted by the claim.
How has the UK legal system approached this tricky task of interpreting claims historically? Has the approach changed over time?
Oh, it's evolved quite significantly over the decades. The much older UK approach was one of fairly strict literal interpretation. The claims were read very narrowly, almost like precise legal boundaries or fence posts marking out the invention. The guiding maxim was often said to be what is not claimed is disclaimed, meaning if the defendant's product didn't match the literal words of the claim exactly, then there was simply no infringement. The EMIV Listen case from 1939 is often cited as a classic example illustrating this strict literal approach.
That sounds quite rigid.
It could be. This strictness was sometimes relaxed slightly if a purely literal reading would lead to a clearly absurd result that completely defeated the patent's obvious purpose, as was acknowledged in Hendrickson v. Talon in 1965. But the starting point was very much literal.
So the default was read the words exactly as written. What about the doctrine of pith and marrow? That sounds less literal.
Yes. The pith and marrow doctrine developed partly as an alternative, or a way to soften the edges of strict literalism. It allowed a finding of infringement even if there wasn't a perfect literal match. The idea was that if the defendant had taken the pith and marrow, the essential substance or core of the invention, they could still be liable. This involved the court trying to identify the essential integers or crucial features of the claim. If the defendant took all the essential integers, perhaps substituting merely mechanical equivalents for non-essential features described in the claim, that could still potentially be infringement. Cases like Marconi v. British Radio, Telegraph and Telephone Co. and Birmingham Sound Reproductions v. Calaro are often used to illustrate this historical concept of identifying essential integers and considering mechanical equivalents.
So that sounds like an attempt to get at the core inventive idea, even if the specific words weren't matched exactly by the defendant.
Yes, that was the aim. But it was often a difficult and somewhat unpredictable doctrine for the courts to apply consistently. And some older House of Lords cases, like Vanderlady v. Bamford's, which involved a type of hayrake, and Rodi and Weinenberger v. Scholl, involving a watch strap design, show that courts were sometimes quite hesitant to find infringement of mechanical inventions under this doctrine, even where the rival products worked in a very similar way but used slightly different physical structures. It sometimes felt a bit like an unpredictable escape hatch from strict literalism rather than a clear principle.
And the source material is very clear on the current status of the pith and marrow doctrine now.
Absolutely crystal clear on this point. The pith and marrow doctrine is now considered to be only of historical interest in UK patent law. It is no longer applied by UK courts when interpreting patent claims for the purpose of assessing infringement. It's history.
Okay, so strict literalism and pith and marrow are essentially historical footnotes now. What came next? What's the modern foundation?
The modern foundation really stems from the introduction of purposive construction by Lord Diplock in the absolutely pivotal House of Lords case Catnick Components v. Hill and Smith. That was back in 1982.
Right, Catnick. That's another one of those case names you absolutely need to know for exams, isn't it? What did Lord Diplock propose with this purposive construction?
Lord Diplock argued that courts should interpret the patent specification, including the claims, purposively, What does that mean? It means the court shouldn't just woodenly read the words in isolation, focusing only on their literal dictionary meaning. Instead, they should ask, what would a person skilled in the relevant art, the notional skill literacy reading this patent, understand the patentee to have intended by using the particular words in the claim? Specifically, would that skilled person understand that strict, literal compliance with a specific term was meant to be an absolutely essential requirement of the invention, or was the term perhaps used more descriptively to indicate the purpose or function required?
Can you remind us of the famous Katnick example itself? How did this work in practice?
Yes, it's a great illustration. The case involved a patent for a galvanized steel lintel used above doorways and windows in building construction. One element of the key claim described the rear support plate of the lintel as extending vertically. The alleged infringing lintel made by Hill and Smith had a rear plate that was actually angled slightly, about 6 or 8 degrees off perfect mathematical verticality. Now, applying a strictly literal reading, there would clearly be no infringement because 84 degrees is not vertical. But Lord Diplock, applying his purposive approach, reasoned differently. He argued that a skilled builder reading this patent would understand that the word vertical wasn't being used in a strict, precise geometrical sense. Its purpose in the claim was simply to describe the general upright orientation needed for the lintel to function correctly and support the load above it. To read vertical literally would mean that even tiny, functionally insignificant deviations from 90 degrees would allow competitors to escape the patent, effectively depriving the patentee of any useful protection for their actual invention. So the House of Lords found infringement, concluding that the skilled person would understand that strict mathematical verticality was not intended by the patentee to be an essential requirement of the invention as claimed.
That feels like a really significant shift, moving away from just the dictionary definition of words towards understanding their function and the inventor's overall technical idea within the context of the patent.
It absolutely was. Purposive construction, as championed in Katnick, aimed to give the patentee fair protection for their actual invention, not just protection limited by potentially imprecise language or minor, functionally irrelevant variations introduced by competitors. It became the dominant approach in the UK for interpreting claims, and largely superseded the old pith and marrow ideas.
How did the European Patent Convention, the EPC, and particularly its protocol on interpretation, fit into this evolving UK approach after Katnick?
That's a very important part of the story. The UK's Patents Act 1977 incorporated Article 69 of the EPC directly into UK law via Section 125. Article 69 itself states that the scope of protection conferred by a European patent, or a UK patent granted under the Act, is determined by the terms of the claims, but that the description and drawings must be used to interpret the claims. Crucially, the original protocol on the interpretation of Article 69, which was agreed back in 1973 and also forms part of UK law, gave specific instructions to national courts on how to interpret claims.
What did the protocol say?
It explicitly stated that courts should avoid interpreting the claims using strict literalism, so confirming the move away from the old UK approach. But it also warned them against treating the claims only as a guideline, where the protection extends just to what the patentee contemplated, which might risk being too broad and vague. Instead, the protocol mandated a middle path. The aim was to combine giving fair protection for the patentee with providing a reasonable degree of legal certainty for third parties, like competitors, about what they can and cannot do without infringing.
So the EPC system itself explicitly told courts to find this careful balance. Don't be too literal, but don't be too vague either. Give fair protection, but also reasonable certainty.
Exactly. That was the core principle. Then came the EPC 2000 revisions, which amended the protocol. Article 1 of the amended protocol essentially reaffirmed this middle ground principle, requiring an interpretation that combines fair protection with legal certainty. But Article 2 of the amended protocol added a very significant clarification. It stated, for the purpose of determining the extent of protection conferred by a European patent, due account shall be taken of any element which is equivalent to an element specified in the claims.
Wow. So the concept of equivalence was formally embedded right there in the EPC's interpretation framework by EPC 2000.
Yes, absolutely. It clearly stated that when assessing the scope of protection, courts must take account of elements that are equivalent to those literally specified in the claims. This put the idea of equivalence right at the heart of claim interpretation under the EPC system.
Okay, so we have Katnick establishing purposive construction in the UK, and the EPC protocol mandating a balance and explicitly mentioning equivalence. How did UK case law evolve as it grappled with applying this protocol? particularly in the period before the most recent big Supreme Court decision?
Well, after Katnick, the Court of Appeal in the Improver Corporation v. Remington Consumer Products Ltd. case, the substantive decision was in 1990, applied the Katnick purposive construction approach specifically to patents granted under the 1977 Act. In doing so, Mr. Justice Hoffman, who later became Lord Hoffman, developed Lord Diplick's more general purposive question from Katnick into a more structured three-stage test. This test was specifically designed to help assess infringement by variance products that weren't literally identical to the claims, but might still be considered infringements under a purposive approach. These became widely known as the improver questions, or sometimes the protocol questions.
What were those three specific improver questions again? They seem important to know.
They are important, yes. They were, essentially. 1. Does the variant, the allegedly infringing product, have a material effect upon the way the invention works? If yes, it's different enough, so no infringement. If no, proceed to Q2. 2. Would this lack of material effect have been obvious to a person skilled in the art at the date of publication of the patent? If no, it wasn't obvious it was the same, so no infringement. If yes, proceed to Q3. 3. Would the reader skilled in the art nevertheless have understood from the language of the claim that the patentee intended that strict compliance with the primary meaning of the term was an essential requirement of the invention? If yes, strict compliance was intended, so no infringement, even if it works the same way. If no, then infringement is established.
So a structured way to apply the Katnick purposive idea specifically to variants that weren't literal copies.
Exactly. And these improver questions became the standard approach used in UK courts for assessing infringement by variants for many years. You see them applied in cases like Daly v. Burchett in 1992 and Wheatley Davina v. Drillsafe Ltd. In 2001. Although it's worth noting there was some division of opinion in the Court of Appeal in the Wheatley case about their application.
Was this approach universally accepted?
Mostly. Although there was some debate along the way, Lord Justice Millett, as he then was, in the PLG Research Ltd. v. Arden case in 1995, expressed some reservations and suggested a slightly modified approach closer to German law, focusing more on what variants the skilled person would have contemplated. However, his comments were obiter, not essential to the decision, and weren't generally followed. The Court of Appeal in subsequent cases like Bewight v. Valmet, 1997, and Kastner v. Rizla, 1995, consistently reaffirmed that reliance on the improver questions was the proper way to apply the protocol in UK law at that time.
Okay, so the improver questions were the standard for a good while. And then came the Kieran Amgen case in the House of Lords in 2005, which seemed to, well, throw a spanner in the works.
It certainly did. Kieran Amgen Inc. v. Host Marion Roussel Ltd. was a hugely influential decision for the House of Lords. Lord Hoffman, giving the leading speech, argued very forcefully that there was ultimately only one fundamental question when it came to claim interpretation. What would a person skilled in the art understand the patentee to have meant by the language used in the claim? He stated quite explicitly that the improver questions were just guidance or factors to consider when answering this single, overriding question. They were not a rigid three-stage test in themselves.
And what was the most significant and perhaps most controversial statement that came out of Kieran Amgen regarding equivalence?
The most impactful statement was Lord Hoffman's explicit declaration that there was no doctrine of equivalence as such in UK patent law. He essentially argued that purposive construction, properly applied, achieved the balance required by the protocol without needing a separate doctrine of equivalence.
But wait, didn't you just say that the amended EPC protocol explicitly requires courts to take equivalence into account in Article 2?
Exactly. This created a clear and significant tension between the highest UK court's interpretation of the law and the wording of the European treaty obligation that the UK was supposed to be following. After Kieran Amgen, the approach to claim interpretation in the UK focused very heavily on a meticulous linguistic analysis of the claim language, viewed within the specific context of that patent and through the eyes of the skilled person. Different words were treated with varying degrees of precision depending on that context. Some terms were seen as requiring strict compliance, almost like the old fence posts. A Klutek v. Aga on the word clamp, Zeno v. BSM, where exact numerical measurements implied precision, while others were interpreted more flexibly or figuratively. Cordes v. Qualchem on the word tailored, Bogli-Graviers v. Darsal on pyramidal teeth being descriptive. The idea of equivalence playing a separate role was essentially rejected.
So, post-Kieran Amgen, the UK seemed to deliberately turn its back on having a formal doctrine of equivalence, despite the clear wording in the EPC protocol. That sounds like an unstable situation. Which brings us, finally, to the absolute latest position from the Supreme Court in the landmark case of Actavis v. Eli Lilly.
Yes, exactly. Activist UK Ltd v. Eli Lilly and Co., decided by the Supreme Court in 2017, is the case that fundamentally redefined the UK's approach to assessing infringement, particularly for variants of the claimed invention, and brought the UK back into line with the EPC.
Why did the Supreme Court feel the need to revisit and effectively overturn the approach set out in Kieran Amgen?
Lord Neuberger, giving the unanimous judgment of the Supreme Court, concluded that the approach adopted in Kieran Amgen, which focused purely on linguistic interpretation and explicitly rejected any doctrine of equivalence, was simply too narrow. Crucially, he stated that the Kieran Amgen approach did not give proper effect to Article 2 of the amended EPC 2000 protocol, which, as we've discussed, clearly requires national courts to take equivalence into account when determining the scope of patent protection.
So the Supreme Court essentially said, look, the EPC protocol mandates considering equivalence, so the UK approach must do that too.
Precisely. Activists, therefore, established a new two-stage test specifically for determining infringement in cases where the alleged infringement is a variant of the claimed invention, meaning it doesn't literally match the claim wording but might be functionally similar. And importantly, both stages of this test are still viewed through the eyes of the person skilled in the art.
Okay, a new two-stage test for variance. What's stage one?
Stage 1 asks, does the variant infringe the claim as a matter of normal interpretation? This is essentially the purposive construction approach we've already discussed, derived from Katnick. It involves interpreting the words of the claim purposively, looking at the context of the whole specification and drawings, all through the eyes of the skilled person armed with their common general knowledge. As was clarified in a later High Court case, Region Lab SAV eStar Medical Ltd. in 2019, this first stage is about interpreting the claim language itself, much like you would interpret the wording of a contract, using the skilled person's understanding. If the variant falls within the claim scope on this normal purposive interpretation, then infringement is found, and that's usually the end of the inquiry.
But what if it doesn't infringe under stage one on a normal purposive interpretation?
Then, and only then, you move to stage 2. Stage 2 asks a different question. If the variant does not infringe on a normal interpretation, stage 1, does it nevertheless infringe because it is an equivalent of the claimed invention? The core idea here is that the variant might differ from what's literally claimed, but those differences are considered legally immaterial to the way the invention actually works.
And do the old improver protocol questions come back into play here in stage 2 to assess this equivalence?
Yes, they do, but in a slightly modified form. Lord Neuberger stated in Activist that the improver questions, although slightly reworded and refocused, remain a useful guideline, not a strict test, for applying this new equivalence assessment required by stage 2. The modified questions, specifically for assessing equivalence at stage 2, are now framed as 1. Notwithstanding that it is not within the literal meaning of the relevant claims of the patent, does the variant achieve substantially the same result in substantially the same way as the invention, i.e. the inventive concept revealed by the patent? Note, the comparison is to the invention as defined by the claims, not just a vague inventive idea. 1. Notwithstanding that it is not within the literal meaning of the relevant claims of the patent, does the variant achieve substantially the same result in substantially the same way as the invention, i.e. the inventive concept revealed by the patent? Note 2. Would it be obvious to the person skilled in the art, reading the patent at the priority date, but knowing that the variant achieves substantially the same result as the invention, that it does so in substantially the same way as the invention? 1. Notwithstanding that it is not within the literal meaning of the relevant claims of the patent, does the variant achieve substantially the same result in substantially the same way as the invention, i.e. the inventive concept revealed by the patent? Note 3. Would such a reader of the patent have concluded that the patentee nonetheless intended that strict compliance with the literal meaning of the relevant claims of the patent was an essential requirement of the invention?
Okay, those are the 3 key questions for stage 2 equivalence. And to find infringement by equivalence at this stage, what must the answers be?
To establish infringement by equivalence under Stage 2, the answers to those 3 questions must be yes to question 1, it works the same way, yes to question 2, it was obvious it worked the same way, and crucially, no to question 3. The patentee did not intend strict compliance with the literal wording to be essential. If the answer to question 3 is yes, meaning the skilled person would understand that strict compliance was intended by the patentee, then there is no infringement by equivalence, even if the variant works in exactly the same obvious way.
Let's try to use the activist case itself to illustrate how this 2-stage test worked in practice. Remind us of the basic facts.
Sure. In Activist, the patent owner, Eli Lilly, had a patent with a specific type of claim known as a Swiss-type claim. This claim was for the use of a particular chemical compound, Pemetrexed disodium, in combination with vitamin B12 for the manufacture of a medicament for treating cancer. The defendants, activists, and others wanted to launch generic versions, but they planned to use other salts of Pemetrexed, such as Pemetrexed ditromethamine or Pemetrexed dipotassium, also combined with vitamin B12.
So the claim specifically mentioned Pemetrexed disodium, but generic versions use different salts of the same active ingredient, Pemetrexed. How did the test apply?
Okay, applying the new two-stage test. At stage 1, normal interpretation, the Supreme Court agreed with the lower courts that activists' products using different salts did not infringe. Why? Because the claim explicitly specified Pemetrexed disodium. On a normal purposive interpretation of that language, the skilled person would understand it to mean exactly that salt and not extend to other salts. So no infringement at stage 1.
Right, so then they moved to stage 2, equivalence.
Exactly. At stage 2, the court applied the 3 modified improver questions. They concluded. 1. Yes, the variants, using other salts, achieve substantially the same result, treating cancer when combined with B12, in substantially the same way as the claimed invention, using Pemetrexed disodium with B12. The different salt form was immaterial to the therapeutic effect. 2. Yes, it would have been obvious to the skilled person at the priority date, knowing the result was the same, that the other salts achieved it in substantially the same way. The salt form was just a common formulation choice. 3, and crucially, no. The skilled person reading the patent would not have concluded that Eli Lilly intended to limit their invention strictly and essentially to the disodium salt alone. The core inventive concept was clearly the use of the Pemetrexed anion in combination with B12. The specific salt form wasn't presented as an essential part of that core concept. Since the answers were yes, yes, no, the Supreme Court found that activists' products did infringe Eli Lilly's patent under the doctrine of equivalence at stage 2.
Wow. So activist is hugely significant then because it formally establishes a doctrine of equivalence in UK patent law, moving decisively beyond the purely linguistic approach of Kieran Amgen and bringing the UK much closer to the interpretation approach used in other major European patent jurisdictions.
Yes, that's exactly right. It undeniably expands the potential scope of protection for patentees beyond just the literal wording of their claims. The flip side, of course, is that it potentially reduces the degree of legal certainty for competitors compared to the stricter post-Kieran Amgen landscape. They now have to worry not just about literal infringement, but also infringement by equivalence.
How are the courts applying this new activist test in practice since 2017? Are there further developments?
Courts are actively applying the two-stage test, yes. The Court of Appeal, for instance, in the IceGate Ltd v. Iceworld International BV case in 2018, acknowledged that Actavis represented a markedly different approach to what came before. However, Lord Justice Sloyd in that case also stressed that patent claims still serve a vital function in defining the scope of the invention. Actavis doesn't mean that claims become vague guidelines just pointing to an inventive concept, which would be contrary to the protocol's warning against treating claims as mere guidelines. The variance equivalence must always be assessed relative to the invention as defined by the claims, not just some broader, ill-defined inventive idea floating around.
Okay, so claims still matter. They anchor the analysis. And wasn't there a very recent case, Vernicare v. Molded Fiber Products, that applied activists and also introduced another key limiting concept?
Yes, absolutely. Vernicare Ltd v. Molded Fiber Products, Ltd., decided by the Intellectual Property Enterprise Court, IPEC, in 2022, is a crucial recent decision for several reasons. It clearly shows the activist equivalence test being applied, but more significantly, it formally recognized and applied, for the first time as a determinative factor in the UK, a limitation on the doctrine of equivalence known as the Formstein defense.
Okay, tell us about Vernicare. What was the product and the issue?
This case involved patents for those disposable molded paper pulp wash bowls, the kind commonly used in hospitals and care homes. One of Vernicare's patents, known as the 793 patent, claimed a wash bowl featuring an enclosing wall comprising recesses, which were intended to form grip means. The description in the patent specification indicated that these recesses were meant to have near vertical sides to aid grip. The defendant's, MFP's, rival wash bowl didn't have distinct recesses with near vertical sides. Instead, it had a single, continuous undulating ridge running around the rim.
So another classic example of a competitor trying to design around the patent claims with a slightly different structure.
That was precisely the core issue for the court. The judge first applied stage 1 of the activist test, normal interpretation. He found no infringement at this stage. He concluded that the MFP product's single undulating ridge didn't fall within the normal purposive construction of a claim that required multiple distinct recesses, which were understood from the description to have near vertical sides. So MFP had successfully designed around the literal purposive scope of the claim.
Okay, no infringement at stage 1. So did the judge then move to stage 2, equivalence, and apply the 3 activist questions?
Yes, exactly. The judge then proceeded to stage 2 and considered the 3 equivalence questions. While he found it unnecessary to give definitive answers to questions 1 and 2, that is, whether the ridge achieved substantially the same result in substantially the same way, and if that was obvious, he found that Wernicke's claim for equivalence would ultimately fail based on the answer to question 3 and because of the application of the Formstein defense.
Right, the Formstein defense. What exactly is it, and how did it apply in Wernicke?
Okay, the Formstein defense is a principle that originates from German patent law. It had been discussed obiter, in passing without being decisive, in a couple of earlier UK cases like Facebook Inc. v. Voxer IP LLC in 2021 and Technetics BV v. Telest Corporation in 2022, but Wernicke was the first UK case where it was actually determinative of the outcome. The defense essentially prevents a finding of infringement by equivalence if the scope of the claim, when notionally expanded to cover the defendant's variant, would also inadvertently encompass something that was already known or obvious from the prior art that existed before the patent was filed.
Ah, okay. So you can't use the doctrine of equivalence to effectively recapture or claim ownership over something that was already in the public domain before your patent.
Precisely. It acts as a safeguard for the public domain. In the Wernicke case, there was evidence of prior art that showed older designs of molded bowls which featured undulating ridges around the rim, somewhat similar to MFP's product. The judge reasoned that Wernicke's claim for recesses, understood as having near vertical sides, was interpreted broadly enough via equivalence to cover MFP's single undulating ridge, then that expanded scope would inevitably also cover these known prior art bowls with undulating ridges.
I see. So how does that impact the third activist question about the patentee's intention?
It impacts it directly. Applying the third activist question in light of this prior art and the Formstein principle, the judge concluded that the skilled person, knowing about this prior art, would understand that the patentee must have intended strict compliance with the literal wording of their claim, i.e., requiring distinct recesses with near vertical sides, precisely in order to ensure the patent's validity over that prior art. If they hadn't intended strict compliance, their patent might have been invalid from the start. Therefore, the answer to question 3 was yes, strict compliance was intended.
So strict compliance was deemed essential to save the patent from invalidity, meaning question 3 was yes, which in turn means no infringement by equivalence under stage 2.
Exactly. The overall outcome for Wernicke's 793 patent was that it was held to be valid because when read narrowly, it was distinguished from the prior art, but not infringed, because MFP's product fell outside that narrow scope and equivalence couldn't be used to expand it due to the Formstein issue. This case is really important because it clearly illustrates the activist equivalence test in action and crucially introduces the Formstein defense as a key limitation on the reach of equivalence, preventing it from encroaching on the prior art. It's a very significant development that anyone studying or practicing in this area needs to be aware of.
That's a fantastic and detailed summary of the really complex evolution of claim interpretation in the UK. From strict literalism, through the historical detour of pith and marrow, to the introduction of purposive construction and catnick, the development and subsequent questioning of the improver questions, the significant pivot rejecting equivalence in Cure and Amgen, and now arriving at the current landmark activist two-stage test, which explicitly embraces equivalence, but which is now clearly limited by the Formstein defense as demonstrated in Wernicke. It's certainly a constantly shifting and high-stakes legal landscape.
It truly is. It's often the absolute core battleground in many, if not most, patent disputes. Getting the interpretation right is everything.
Let's try and quickly apply some of these interpretation concepts, maybe using the Bellavron heated roller example from the source's sample questions, just to see how it might play out. So, Levron has a patent for a heated hair roller with some specific features claimed. A round tube, a substantially circular inner chamber containing hair conditioning gel, and having 1 millimeter diameter perforations for the gel to come out. Bella has launched a rival product that differs slightly. Its tube is elliptical, the inner chamber is oval, it uses hair conditioning liquid instead of gel, and its perforations are smaller, 0.75 millimeters in diameter. Bella manufactures these rollers in France, but sells them into the UK via a UK subsidiary company, Largesse, and also directly via online sales accessible in the UK. What are the infringement issues here?
Okay, let's step through that using the framework we've discussed. First, the infringing acts. Bella's actual manufacture in France is, as we establish, not a UK infringing act itself due to the territorial limit. However, Bella offering the rollers for sale or selling them via a website accessible to UK customers could constitute offering to dispose of or disposing of under S601 in the UK. Lorges, the UK company distributing them, is almost certainly committing multiple direct infringing acts under S460 within the UK. They're likely importing the rollers from France, offering to dispose of them, for example, via catalogs or their own website, disposing of them, selling them to retailers or consumers, and keeping them holding stock. So plenty of potential infringing acts happening in the UK.
Okay. Are there any obvious defenses here for Bella or Largesse before we get to interpretation? Things like exhaustion, prior use, or the statutory S.605 defenses?
Looking at the facts given, exhaustion seems unlikely unless Livron themselves had previously put these specific rollers on the market somewhere else in the EEA with consent, which isn't suggested. Prior use would require Bella or Jess to prove they were doing these specific acts, making, using, selling this particular variant roller, before Livron's patent priority date, which again isn't suggested by the scenario. And the statutory defenses under 2605, like private use or experimental use, clearly wouldn't apply here. This is purely commercial activity. So apart from potentially challenging the validity of Livron's patent itself or arguing non-infringement based on the claim scope, the specific defenses seem quite limited on these facts.
Right. So the main fight is almost certainly going to be about claim interpretation and specifically applying the Actavis test because the Bella product is clearly a variant, not a literal match to Livron's claims.
Exactly. Livron will sue Largesse, and maybe Bella, for infringement, arguing that Bella's elliptical oval chamber liquid-using 0.75mm hole roller infringes their claims for a round circular chamber gel-using 1mm hole roller. The court will have to apply the Actavis two-stage test.
Okay, stage one, normal interpretation, purposive construction. How might that play out?
Well, under stage one, Livron's claims use some quite specific descriptive terms: round tube, substantially circular inner chamber, hair conditioning gel, and 1mm diameter perforations. Bella's roller differs on all these points: shape, elliptical oval versus round circular, the conditioning substance, liquid versus gel, and the hole size, 0.75mm versus 1mm. Applying purposive construction, the court has to ask if the skilled person reading the patent would understand that Livron intended strict compliance with these specific features, or if they were perhaps meant more broadly or descriptively. Given the very specific mention of gel, contrasted with liquid, and the precise dimension 1mm diameter for the perforations, it's quite possible, perhaps even likely, that a court might find that using a liquid instead of gel, or using a different smaller hole size, are differences that are material under a normal purposive interpretation. If so, that would lead to a finding of no infringement at stage one.
Okay, so let's assume, for the sake of argument, the court finds no infringement at stage one based on the specific wording. Then we have to move to stage two, equivalence. Livron would then argue that Bella's variant roller is nonetheless equivalent to their claimed invention.
Right. LeBron would need to apply the three modified activist questions to make their case for equivalence. Question 1. Does Bella's variant achieve substantially the same result, conditioning hair while heating it, in substantially the same way, by having a conditioner pass through perforations from an inner chamber onto the hair during heating? Plausibly, yes, the overall function seems similar. Question 2. Would it have been obvious to the skilled person at the patent's priority date that using a liquid instead of a gel, or using 0.75mm holes instead of 1mm holes, perhaps specifically for a liquid, would achieve substantially the same result in substantially the same way? Again, possibly. Depending on the common general knowledge about hair conditioners and roller design at the time, these might be considered obvious alternative choices or minor modifications by the skilled person.
But question 3, about the patentee's intention for strict compliance and also the potential application of the Formstein defense, seem like the really big hurdles here for Livron, trying to claim equivalence.
Precisely. Question 3 asks, would the skilled person reading the patent have concluded that Livron nonetheless intended that strict compliance with the literal meaning of round tube, substantially circular gel, and 1mm diameter was an essential requirement of their invention? This is where the specific language becomes absolutely critical again. For example, Bella would argue strongly that the skilled person would think the specific 1mm hole size was chosen deliberately because it was optimal for the viscosity of the claimed gel, and that a different size, like 0.75mm, might be needed or better suited for a liquid. This could suggest that the choice of substance and hole size were linked and intended to be specific, meaning strict compliance was intended, so Q3 excess.
And the Formstein defense?
Bella would also investigate the prior art very carefully. Perhaps prior art existed showing earlier heated rollers that used liquid conditioners, maybe even with different hole sizes. If such prior art exists, then extending the scope of Levron's claim, which specifies gel and 1 millimeter holes, via equivalence to cover Bella's liquid 0.75 millimeter version, would risk encompassing that prior art. If so, the Formstein defense kicks in. Bella would argue that the skilled person, knowing this prior art, would conclude that Levron must have intended strict compliance with gel and 1 millimeter, precisely to avoid their patent being invalid over that prior art. Again, this would lead to the conclusion that the answer to question 3 is yes.
So Bella's argument would be that stage 2 equivalence fails because when question 3 is yes, either due to the specific technical choices implied by the claim wording itself or because of Formstein implications arising from the prior art, meaning no infringement by equivalence. Levron would, of course, argue the opposite, that question 3 should be no, and the differences are immaterial.
That would undoubtedly be the core of the infringement battle on these facts. And of course, in parallel, Lorges and Bella would almost certainly file a counterclaim seeking revocation of Levron's patent altogether. They would argue under S.721a that heated rollers using conditioners were already known or were obvious developments challenging novelty or inventive step, or maybe under S.721c, that Levron's patent specification isn't sufficient because, for example, it only describes how to make the roller work with gel, but doesn't enable someone to make it work properly across the full claim scope if Levron tries to argue the claim implicitly covers liquids too, raising a biogen-type insufficiency argument.
That example perfectly illustrates how all the pieces we've discussed really fit together in practice, identifying the potential infringing acts under S60, considering the limited scope of specific defenses, the absolute centrality of claim interpretation using the activist test for variance, including equivalence and Formstein, and the almost inevitable counterclaim for revocation based on the grounds in S.72, linking back to patentability requirements in S.1.
It really shows why patent litigation is so complex and often swings on these very detailed points of law, interpretation, and technical fact. There are many layers to consider.
We have certainly covered a tremendous amount of ground today. Let's try and bring it all together now in Section 6 and just summarize again the key issues that you would typically expect to encounter and that a court would have to resolve in a typical patent infringement action in the UK.
Okay. Based on our deep dive through the source material today, the main questions a court generally has to answer when faced with a patent infringement case are typically these 4, which encompass everything we've discussed. 1. First, has an act defined as prohibited in Section 60 of the Patents Act, 1977, actually been committed by the defendant within the UK? Was there factually a making, a using, a selling, an importing, an offering, keeping, or supplying of essential means? 2. Second, does that act, when assessed against the patent claims, fall within the legal scope of the patent? This is the crucial claim interpretation step, now governed by the activist 2-stage test for variance, which involves considering both normal purposive construction and the doctrine of equivalence, potentially limited by concepts like the Formstein defense. 3. Third, even if the act falls within the scope, are any specific statutory defenses, like those found in S.605 for private or experimental use, or S.64 for prior use, or perhaps relevant case law concepts, like exhaustion of rights, the implied license to repair, or even the strategic Gillette defense, applicable on the facts that would legally excuse the defendant's conduct. 4, and fourth, perhaps underlying everything else, is the patent itself actually valid? Have the defendants successfully proven any of the grounds for revocation set out in Section 72, particularly those relating back to the core requirements for patentability in Section 1, like novelty and inventive step, or relating to the sufficiency of the patent's description under Section 72.1?
So it boils down to proving the action happened, proving the patent claims cover that action, which involves careful interpretation, checking if there are any specific legal excuses or exceptions, and fundamentally checking if the patent itself should even exist. That's the litigation roadmap in a nutshell.
That is indeed the essential framework that a court will typically apply when navigating a patent infringement dispute.
Wow. We've really gone deep into this area today. From the basic definition of infringement as a statutory tort, through all those specific prohibited acts, like making, and remembering the crucial Schutz v. Werit case, distinguishing making from repair, using, selling, importing, and keeping. We covered indirect infringement and the important staple commercial product defense. We looked at the various ways a defendant can defend themselves, including those specific statutory exceptions like experimental use, remembering Corval's main purpose test, and the prior use defense. We discussed the key case law doctrines like exhaustion of rights, Centrifarm, and the implied license to repair, Schutz again, and that clever strategic Gillette defense. We also explored the very powerful option of challenging the patent's validity through revocation, understanding the crucial grounds like lack of patentability, bringing in S.1 concepts, and insufficiency, including biogen insufficiency. And, of course, we spent significant time on the complex but absolutely central issue of claim interpretation, tracing its evolution from the old days of literalism and pith and marrow through the arrival of purposive construction, catnic, and the development and temporary sidelining of the improver questions, the controversial pivot in Kieran Amgen rejecting equivalence, leading finally to the current landmark Actavis two-stage test, which explicitly embraces a doctrine of equivalence, but which is now clearly constrained by the important Formstein defense as demonstrated in Wernicke.
It truly is a fascinating and dynamic area of law. It's constantly being shaped and refined by court decisions as judges strive to achieve that difficult balance between properly rewarding genuine innovation through patent protection while also ensuring that competitors and the public have a reasonable degree of certainty about what technology is free to use and build upon.
Understanding this whole framework is clearly essential, whether you're someone aiming to protect your own inventions or maybe a business needing to navigate the world of existing patented technology held by others, or perhaps you're just interested, like us, in the legal boundaries that shape technological progress.
Absolutely. It's fundamentally about how the law defines and polices the lines drawn around these temporary legal monopolies that we grant in the realm of innovation.
It really makes you appreciate the complexity involved in drawing those lines fairly. And thinking about that significant shift in activists explicitly bringing in equivalence and then the counterbalance provided by the Formstein defense limiting its reach. It leaves you wondering, doesn't it? Does the current approach feel like it strikes the right balance? Just how far should the scope of a patent really extend beyond the precise words the inventor happened to choose in their claims? Does the laudable goal of giving fair protection to the patentee inevitably mean that competitors can never be fully certain about what's truly free to use? Or does the Formstein defense now provide an adequate safeguard to prevent patentees from using equivalence to effectively claim something that the public already knew?
Those are exactly the sorts of difficult, fundamental policy questions that the courts continue to grapple with in this area, constantly refining the application of the law in this very dynamic field. There are no easy answers.
Indeed. Well, on that thought-provoking note, once again, we want to extend our sincere thanks to the University of London for making these incredibly useful materials available for educational use. And remember, this deep dive was proudly brought to you by Sinorbit Academy, Sri Lanka.
And we sincerely hope this detailed exploration has been helpful for you in clarifying these complex but important topics. To everyone out there preparing for your exams, keep reviewing these key statutory provisions, especially Sections 60, 62, 64, 72, and 125 of the Patents Act. Make sure you understand the core concepts we've discussed. Making versus repair, remembering shoulds, the different knowledge requirements for infringement, the staple commercial product defense, experimental use, and the core valve main purpose test, the Gillette defense, the different types of insufficiency, classic and biogen, and absolutely spend time getting your head around the crucial evolution and current application of claim interpretation. Know the journey from Catnick and Kieran Amgen to the current activist two-stage test, and understand the significance of that limiting Formstein defense highlighted in Wernicke. Keep reviewing those key cases and the legal principles they established. We wish you the very best of luck.
Yes, absolutely. Put in the work, revisit the source material and your own notes from related chapters, particularly those on patentability requirements, Section 1, and maybe the structure of patents and the application process. It will all help click into place. Thanks so much for joining us for this deep dive.
Thank you.